All right, y'all, what's up, man? So I got the transcript. I got the transcript from the hearing, uh, September the 25th. September 25th, 2025, right here. Okay. So I wasn't able to go. I was in Chicago with Little Sean. Me and Little Sean went to see the Mets play the Cubs at Wrigley Field. We was there for 2 days. We went to both games. We went to 2 games. So the crux of this hearing was for Judge Subramanian to hear the oral arguments on a Rule 29, which is a flat-out acquittal based on insufficiency of evidence to justify an acquittal, and also a Rule 33, which is to ask for a new trial. So the 2 assistant U.S. attorneys who argued this, for the Southern District of New York was Emily Foster, Meredith Foster. Yo, what's up, man? Same thing. All the fish still swimming? Everybody swimming? Ain't nobody floating, so everybody's still alive. So look, just turn on the light, man, and feed them, and then when they finish eating, you could just turn it off, and then we'll be there tomorrow. And I appreciate you, man. You get that Zell? What, Luna there? All right, cool. Yeah, for the algae eaters. Yeah, definitely put them in there for them. Yeah, give us some new water. Appreciate you, man. Please. No, we went to 2 games. We went to 2 in Chicago. They won the 2. They lost 1 and they won 1. So they still a game ahead of Cincinnati. And they down in Miami now. They winning the game in Miami so far. So they just got to win out. They won out, they get in. Yeah, she can eat. But look, I'm shooting some content. Yeah, definitely. Both. All right, later. That's my man feeding my cat and my fish for me while we was on the trip. So Meredith Foster and Mary Christine Slavic are arguing for the Southern District of New York against Judge Subramanian giving Puffy a Rule 29 acquittal or a Rule 33 new trial. Both of them lost. They are part of the losing team. Mary Christine Slavic was a loser at trial, the Puffy trial in the Southern District of New York against Puff. And so was Meredith Foster and Mary Christine Slavic. They both were losers. They were on the losing team during the RICO trial and the SCX trafficking trial. So the losers are coming to argue again against Puffy getting a new trial in the Rule 33 or getting acquitted on the Rule 29. Now, their argument is the Southern District of New York's argument is that at the jury instruction, Puffy and his defense team agreed to the definition of what prostitution was, and I think even in here they allege that Puffy came up with the definition of what prostitution should be. So that in and of itself should make the conviction stick, and also that this argument that he's kind of forfeited his right to either Rule 29 or Rule 33 because he didn't bring this up at the Rule 12 stage. Like, he needed to bring this up at the jury instruction stage. And of course, Alexandra Shapiro, who was on the winning team, elite level appeals lawyer. Alexandra Shapiro, probably the best in the country, one of the best. She is arguing that, man, knock it off with that, chill with that. We could bring this up, and she's giving reasons why, legal statutes why she can bring this up. So, I've read Foster's oral argument, and that's pretty much all she's got. She cites some cases, Dennis case, a Crowley case, as to kind of as precedent cases to justify why Puffy shouldn't get a new trial on a Rule 33, and he shouldn't get an acquittal under Rule 29. But Judge Subramanian is pushing back on some of her arguments, and then he turns over the floor to Alexandra Shapiro, and Alexandra Shapiro, being the elite level legal mind lawyer that she is, she begins to quote 19th century definitions of what the Mann Act, and what Alexandra Shapiro says is that you have to have the mens rea, right? Or the mens hold on, I'm gonna find it. The mens rea, and there was another joint she said. I'm not gonna worry about that. But anyway, what she's saying is that in order to be convicted of a crime, you have to have the criminal intent, right? The mens rea. Like Puffy had to have known that he was setting out to do prostitution, right? That he knew he was doing that, and that was never established, right? That he didn't do what he was doing because he thought, I'm engaging in prostitution. Alexandra Shapiro, so that's number one. Number two is there's no financial motive. Like, he didn't have a financial motive, okay? That has to be, that the Department of Justice has let that be known, that that is a requirement to even bring a case in federal court related to prostitution, pimping, a brothel, those types of situations, right? She raises cases from the Second Circuit. I think one case that she had overturned in July. She raises that there was a similar situation. And she goes on to say that in the initial statute of the Mann Act, it talked about that it was sex for hire, right? And in the initial Mann Act, it could have been sex for hire or not sex for hire. Even polygamy would have been considered prostitution, or having a concubine, like multiple women, that would have been considered prostitution. And she cites all of these cases. Then she brings up the First Amendment argument that, you know, I have a right, you have a right to set up your iPhone camera, your Samsung camera, your Samsung phone, and film you having sex with whoever you want. That's within your home. That's well within your legal right to do that. And that's a First Amendment right. And if you can't prove that there was a financial motive, that there was mens rea, that there was the intent to set out to engage in, that you were setting out to do it, then it becomes a constitutional issue on the First Amendment. You know, I'm allowed to do that, right? What else is some of the arguments? Also this, that the majority of the times that the male escorts were transported, because that's what the Mann Act was about, transporting beyond state lines, Cassie set it up. She paid them. She arranged the travel instructions, the travel itinerary. Jane arranged the travel. Jane booked the details. Jane paid. Cassie paid, right? That, you know, Puff was in the background and these women were up front orchestrating all of this. But what the Southern District of New York is saying, Meredith Foster, who lost at trial, she's a part of the losing team, she's arguing that there's some kind of secondary liability, that the fact that he is the ultimate he suggests it, that by his mere suggestion of inviting a male escort, that right there makes him guilty. You know, even though he was sitting back, you know, filming the joint. Yeah, yo, put your leg up right there. Yeah, hit it from the back right there. Yeah, go and open the refrigerator door and put your foot on the mustard, put your foot on the orange juice, and then and then cook some eggs at the same time. You hit it like that. That him doing that implicates him for prostitution. And then they go on to talk about the 1986 amendment to the Mann Act, where the initial language that included debauchery and for an immoral purpose, because initially when the Mann Act was set up, it had to be for an immoral purpose or debauchery, right? And you know, in 1986, they took that language out and inserted some new language. And Alexandra Shapiro is saying that, you know, in California and in New York, she cites some state cases that the state courts are saying that it has to be party A pays party B to have sex with party A, right? That has to be the undergirding, that has to be the structural foundation of the act in order for it to qualify as prostitution. And that's not the case in Puffy's case. And Judge Subramanian is agreeing with everything that Alexandra Shapiro was saying. He's agreeing with it. And you know, he's saying one thing, and you know, she disagreed with him. Your Honor, yeah, I hear you, but I disagree. And then she lays out her facts as to why she disagrees to support her argument. And to me, from what I read, he is agreeing with everything. He's agreeing more so with Alexandra Shapiro than he is with Meredith Foster from the Southern District of New York, the Assistant U.S. Attorney who lost at the initial trial. Ms. Shapiro, page 15. Page 15. No, those are alternative requirements. So our argument is that the statute should be construed narrowly, essentially to only apply to pimping, commercial purveyors of prostitution, or in the alternative, at the very least, it can't be applied to this particular situation, not only because Puffy was merely an alleged consumer, but because this is a wire type case. First of all, and sort of most fundamentally, Alexandra Shapiro, page 16. The point in these cases that we cited, where a number of states have held that prostitution only involves an exchange between A and B, where A is paying B to have sex with A. The purpose of that would be entirely defeated if the government could get around that with any theory of secondary liability. For instance, some of those cases involve things like a person at a booth who's watching one or more people engage in sexual activity, but not touching the person who's watching. And those cases are very clear that in those states, those courts are saying that is not prostitution. The Mann Act, here it is, the actus reus of the Mann Act is the transportation. And certainly the Mann Act, the actus reus of the Mann Act is the transportation. And certainly the government's theory, presumably about transportation, is that somebody else was doing the transport, but it was at Mr. Combs's direction. But the other part of the crime is the mens rea, the intent that the transportation will result in people engaging in prostitution. If we're right that prostitution doesn't include commercial voyeurism, I'll call it, and that's the term that some of the cases use, then you can't say that he's willfully causing that, because then there's no point to the rule at all. So Alexandra Shapiro, man, it's all over this thing, man. Alexandra Shapiro was all over this thing, and Judge Subramanian agrees with her. And from what I read, he agreed more with her than with Meredith Foster. So now I just got to the part where now he's talking about, what's her name? Christine Slavic, Mary Christine Slavic, is going to argue the other two questions. So I'm going to get on that right now, and I'm going to hit y'all with another video. Peace.